May 1, 2023 Unit 2 Law of Agency Vocab Quiz. Agency. Agency coupled with an interest. Agent. Attorney in fact. Customary authority. Dual agency. Equal dignities rule. Estoppel. Express agency. Express authority. Fiduciary duty. General agent. Implied agency. Implied authority. Ostensible agency. Power of attorney. Principal. Ratification. Respondent superior. Secret agent. Special agent. Tort. Vicarious liability. 1. What is agency? A. A legal term used to describe a business relationship between two parties. B. A legal document used to transfer ownership of property. C. A document that outlines the terms of a lease agreement. Answer. A. 2. What is an agency coupled with an interest? A. An agency relationship where the agent has a personal stake in the transaction. B. An agency relationship where the agent only represents one party. C. An agency relationship where the agent has no personal interest in the transaction. Answer. A. 3. Who is an agent? A. A person who represents another person in a transaction. B. The person who hires a real estate agent. C. A person who buys or sells real estate. Answer. A. 4. What is an attorney in fact? A. A person who is authorized to act on behalf of another person. B. A person who is authorized to practice law in a particular state. C. A person who is authorized to represent a buyer or seller in a real estate transaction. Answer. A. 5. What is customary authority? A. The authority given to an agent by custom or practice. B. The authority given to an agent by law. C. The authority given to an agent by the principal. Answer. A. 6. What is dual agency? A. An agency relationship where the agent represents both the buyer and the seller. B. An agency relationship where the agent only represents the buyer. C. An agency relationship where the agent only represents the seller. Answer. A. 7. What is the equal dignities rule? A. A rule that requires certain agreements to be in writing. B. A rule that requires both parties in an agency relationship to have equal power. C. A rule that requires an agent to treat both parties in an agency relationship equally. Answer. A. 8. What is estoppel? A. A legal doctrine that prevents a party from denying the truth of a fact. B. A legal doctrine that requires a party to act in good faith. C. A legal doctrine that allows a party to withdraw from a contract. Answer. A. 9. What is express agency? A. An agency relationship that is created through a written or oral agreement. B. An agency relationship that is created through custom or practice. C. An agency relationship that is created by law. Answer. A. 10. What is express authority? A. The authority given to an agent through a written or oral agreement. B. The authority given to an agent by law. C. The authority given to an agent by the principal. Answer. A. 11. What is fiduciary duty? A. A duty that requires an agent to act in the best interests of the principal. B. A duty that requires an agent to act in the best interests of the agent. C. A duty that requires an agent to act in the best interests of both parties in an agency relationship. Answer. A. 12. What is a general agent? A. An agent who is authorized to perform a broad range of tasks on behalf of the principal. B. An agent who is authorized to perform a specific task on behalf of the principal. C. An agent who is not authorized to perform any tasks on behalf of the principal. Answer. A. 13. What is implied agency? A. An agency relationship that is created through the actions of the parties involved. B. An agency relationship that is created through a written or oral agreement. C. An agency relationship that is created by law. Answer. A. 1. What is the legal term for the principal that holds an employer responsible for the actions of its employees in the course of their employment? Answer. Respondent superior. 2. What is the term used to describe an agency relationship created by the conduct of the parties rather than by express agreement? Answer. Implied agency. 3. What is the legal term used to describe the situation where an agency relationship is created by the actions or words of the principal which leads a third party to believe that the agent has authority to act on behalf of the principal? Answer. Ostensible agency. 4. What is the legal document that gives one person, the attorney in fact, the power to act on behalf of another person, the principal? Answer. Power of attorney. 5. In an agency relationship, who is the person or entity that authorizes another person, the agent, to act on their behalf? Answer. Principal. 6. What is the term used to describe the act of accepting or confirming the actions of an agent that were taken without the principal's authorization? Answer: ratification. 7. What is the term used to describe a person who acts on behalf of a principal without disclosing their agency relationship to a third party? Answer: secret agent. 8. What is the term used to describe a person who is authorized by a principal to perform a specific task or act on their behalf for a limited period of time? Answer: special agent. 9. What is the legal term used to describe a wrongful act that results in injury or damage and for which the injured party may seek compensation? Answer: tort. 10. What is the legal term used to describe the situation where a person or entity is held responsible for the actions of another person, even though they did not directly cause the harm? Answer: vicarious liability. Unit 2 Law of Agency Review. Agents and agency defined. Section 2295 of the California Civil Code states, an agent is one who acts for or represents another, called the principal, in dealings with third people. Such representation is called an agency. Therefore, an agent is one who acts for or represents another. A general agent has the authority to perform all necessary acts for the principal within a specified area. While a general agent has broad powers to act for the principal, a special agent is limited to those acts specifically set forth in the agency agreement. A power of attorney is a written agreement whereby a principal appoints an agent, known as an attorney in fact, to act in her place. How agencies are created. Express agency. An express agency is an agency created by a specific agreement, either written or oral. Most agencies are express agencies. Listings are the written agency agreements used to authorize an agent to procure buyers or lessees or to locate property for purchase or lease or to locate property for a buyer or lessee. Implied agency. Most agencies are express agencies created by written or oral agreement. An implied agency is not the result of a stated agreement but is created by the actions of the parties that indicate reasonable intent to form an agency. As an example, an owner who tells a broker, "Find me a tenant," is implying that there should be an agency relationship. Agents should be a word that promises to serve the best interests of another could be construed as an agreement to act in an agency capacity even if the promise is gratuitous. An agency is ostensible when the principal intentionally, or by want of ordinary care, causes a third person to believe another to be his agent who is not really employed by him. For example, assume a real estate agent took a prospective tenant to a property owner's place of business and asked the owner of the property for the key to show the property. Agency of estoppel. When an ostensible agency is created and a third person reasonably acts to that person's detriment based on the belief of the existence of the agency, the person who allowed the ostensible agency to exist would be estopped, barred, from denying the existence of the agency. For example, assume an out-of-town owner informed a broker that the owner's cousin had the authority to give a listing on the owner's property. The broker, acting on this assertion, listed and then procured a buyer for the owner's property. The owner would be estopped from denying the existence of the agency because his other words led the broker to act to the broker's detriment. The agency created what is called an agency by estoppel. Agency by ratification. By accepting the benefits of an agreement made by an unauthorized agent or by an agent who has exceeded his authority, a principal can form an agency by ratification. If a principal had the authority to permit the unauthorized act at the time it was performed, the principal has the authority to ratify or approve the act after it was done. Dual agency. A dual agency exists when an agent represents two principals who are negotiating with each other and have conflicting interests. Any conduct that reasonably leads a buyer to believe that a seller's agent is representing both buyer and seller might create a dual agency. Agency disclosure. Because of misunderstandings by buyers and sellers as to whom the agent represents and what the agency duties are, California required the agent to provide a written agency disclosure to the parties for the sale, purchase, exchange, or lease of 1 to 4 residential units and mobile homes. There are 3 steps in agency disclosure. 1. Disclose a written explanation of the types of agency relationships that are possible. 2. Elect a decision about the type of agency relationship for the transaction. 3. Confirm a written signed confirmation of agency, usually part of a purchase agreement. Authority of agents. Express authority. Agents have the stated authority given to them in the agency agreement, either oral or written. This is known as express authority. A person cannot orally authorize an agent to perform an act that is required to be in writing. According to the Equal Dignities Rule, if the statute of frauds requires the act to be in writing, the agency agreements, such as listings and sales contracts, must be in writing to be legally enforceable. Implied authority agents also have implied authority to perform the acts reasonably necessary to accomplish the purpose of the agency. For example, a managing agent with the power to enter into commercial leases has the implied authority to engage an attorney to draft a lease. Customary authority is authority implied by the agent's position. Fiduciary duty: an agent has a duty of trust and must protect the principal's interests. Under this fiduciary duty, the agent must act in a manner that is consistent with the best interests of the principal. The agent may not obtain any advantage over the principal by misrepresentation, duress, or adverse pressure. A dual agency in which the agent is employed by written contract with a seller to sell a property and is also undertaking to assist the buyer in purchasing that property presents a peculiar and touchy question of duty. An agent may not act for more than one party in a transaction without the knowledge or consent of all the parties thereto. Full disclosure notice to an agent is considered to be notice to the principal. Therefore, the agent has a duty to inform the principal of any facts that would be likely to influence the principal in making a decision. Unless expressly instructed by the owner not to present such an offer, or unless the offer is patently frivolous, every offer received, whether oral or written, must be communicated promptly to the principal. For example, offers must be presented even if received after the principal has accepted an offer and is contractually bound. The best rule for agents is to present all offers to the seller and let the seller decide to accept, reject, or counteroffer. Loyalty: the agent cannot, without permission, disclose to third parties any confidential facts about the principal or the agency that would not be in the principal's best interests. This duty continues even after the agency has terminated. A dual agent cannot disclose to one principal information received in confidence from the other principal, such as that the seller will accept less or that the buyer will pay more. Agent's duty to third persons: an agent has a duty of honest and fair dealings with others. A tort is a civil wrong or a violation of a duty. Civil wrongs that are torts include libel, slander, trespass, assault, negligent injury to others, etc. Some torts, such as assault or trespass, could also be crimes. Liability of principals: the doctrine of respondent superior is that a master is liable for the actions of servants or employees. The principle also applies to agencies. Vicarious liability is created not by an act of the principal but because the agent was acting for the principal. Termination of agency: an agency agreement may be ended in a number of ways. 1. Expiration of its term: an agency automatically ends with the expiration of its stated term. 2. Extinction of the subject matter: the destruction of the property automatically terminates a listing or a management agency agreement in the absence of any agreement to the contrary. In other words, impossibility terminates the agency. For example, if an agent were employed to find a tenant for a property, the destruction of that property would terminate the agency. 3. Death: because an agency is a personal relationship, death of either the principal or the agent terminates the agency. If either the principal or the agent is a corporation, the death of corporate officers would not terminate the agency because a corporation is considered a separate legal entity. 4. Renunciation: because an agency requires consent of the parties, either the principal or the agent can renounce the agency. As stated earlier, if a party wrongfully breaches the agency, that party could be liable for damages. 5. Incapacity of agent or principal: if the agent is no longer capable of acting as an agent, or if the principal becomes mentally incapacitated, the agency terminates. Agents who lose their license would be incapable of performance, so the agency would terminate. 6. Agreement of the parties: the principal and the agent can mutually agree to terminate their agency. 7. Full performance: satisfactory completion of the object of the agency terminates the agency. 8. Bankruptcy: the trustee in a bankruptcy can terminate an agency or allow it to continue. If the bankruptcy of an agent impairs the agent's ability to perform, the principal can terminate the agency. In an agency coupled with an interest, the agent has an interest in the subject matter of the agency. Unit 2 Law of Agency Unit Quiz 1. A legal agency requires that the parties consent to the agency. 2. An agency relationship could be created by all of the following except A. Court order. B. Verbal agreement. C. Implication. D. Ratification. Answer: except A. Court order must be consensual. 3. The relationship that exists between a broker and an owner under a listing is most likely. B. A special agency to procure a buyer or property. 4. An agency created by a principal who intentionally, or by want of ordinary care, causes a third person to believe another to be his agent, who is not really employed by him, would be c. An ostensible agency. 5. You made a statement that induced a person to act as a result of relying on that statement. The legal principle that now prevents you from asserting facts that are contrary to your previous declaration is known as a estoppel. 6. Broker Thomas, who was not your agent, told prospective tenants that he was your agent to lease your property. Thomas leased your property, and you accepted the rent from the tenant. You may not now deny the agency because of a ratification. You accepted the benefits. 7. An undisclosed agent breached a contract with a third party. Which of the following is a true statement as to liability for the breach? A. The agent could be held personally liable. B. The principal could be held liable. C. The agent and the principal would be jointly liable. D. Both A and B are correct. Answer D. Either but not both can be held liable. 8. A selling agent can represent A. The buyer only. B. Both buyer and seller. C. The seller only. D. Any of these. Answer D. 9. A real estate agency disclosure form is required to be given to the buyer and the seller of A single-family home. B. A strip mall. C. An office building. D. All of these. Answer D. 10. An agent failed to give an owner a copy of the agency disclosure form at the time the residential listing was taken. The most likely consequence for the agent will be B. Inability to collect a commission should a sale be made. 11. Which is not a requirement of an agency relationship? A. Compensation to the agent. B. Contractual capacity of principal. C. Loyalty of agent to principal. D. Full disclosure by agent to principal. Answer is not A. Compensation to the agent. 12. The equal dignities rule concerns B. The requirement that certain agency agreements be in writing. 13. Which statement is correct as to agencies? D. Some agency duties are implied. 14. A seller's agent, in selling a home, must B. Disclose the agency representation to both buyer and seller. 15. A fiduciary relationship exists between a broker and his principal. 16. A seller's listing agent is required to B. Disclose to a buyer all known material facts that affect value. 17. A dual agent must A. Tell the buyer that the seller will accept less. B. Tell the seller that the buyer will pay more. C. Require compensation from both buyer and seller. D. Do none of these. Answer D. 18. Agents could be held personally liable if they A. Claim to be acting as a principal. B. Made false representations upon the direction of their principal. C. Exceeded their authority. D. Did any of these. Answer D. 19. An agent exceeds a secret limitation in the agency agreement while dealing with a third party. Which statement would be correct? A. The agent could be personally liable to the principal. B. The third party could hold the principal liable for the agent's action. C. Both of these are correct. Answer is C. 20. Which is true about real estate agents' liability? D. An agent can be held liable for a tort committed by the agent during the agency. 21. When an agent commits a tort while carrying out agency duties, the D. agent would be personally liable for the tort. 22. When broker Clyde died, he had 36 exclusive listings. The executor of his estate, who was also a broker, wanted to continue the business until it could be sold. The executor must C. Renegotiate all listings. Death terminated the agency agreements. 23. All these events would terminate an agency except A. The death of a corporate officer of the agent's principal. B. Agreement of the parties. C. Renunciation by the principal. D. Extinction of the subject matter. Answer is except A. The death of a corporate officer of the agent's principal. Corporation is a separate entity. 24. An agency for a stated period of time would be terminated before the expiration date by all these except A. Termination by the principal without cause. B. Termination by the agent. C. Refusal of the principal to accept an offer. D. Destruction of the subject matter of the agency. Answer is except C. Refusal of the principal to accept an offer. 25. A principal may not unilaterally terminate an agency when b. The agency is coupled with an interest.